Good morning, everyone. Good afternoon for people on the East Coast. Thanks so much for joining us today. We're going to talk about divorce. So my name is Vrinda Gandhi. I have been with Chugh since 2011. I've been practicing family law since then. And for those of you who don't know, I did my own divorce in 2014. So that kind of made me an expert in divorce and in terms of having empathy for our clients. In my free time, I like to do yoga, meditation, I like to read, and I love cooking. So that's a little bit about me. Raji, why don't you go and introduce yourself?
Hi, everybody. Thank you so much for your time and thanks for joining us on the call. Thanks, Brinda. I am Rajashri Rajasekharan, Raji, for everybody else that's interacted with me. I am an attorney with the Santa Clara office, and I look forward to the presentation today. We'll just get started. So before we dwell into this whole thing, I just want to say Brinda and I have tried to make this as lighthearted as possible because we both know that a divorce process tends to have a lot of psychological and physical stress on the parties that are involved. So hopefully you enjoy this presentation. Have you guys seen the new Barbie doll? She has all of Ken's stuff. So the way that we're trying to move around with this presentation is to ensure that all the Barbies don't end up with all of Ken's stuff, so that there's a fair distribution of the assets and debts involved. Now, as all of you know, marriage is the number one cause of divorce, not just in America, but everywhere across the world. But like I previously mentioned, a decision to file a divorce is certainly not an easy one, not just because of the ramifications it has between the two parties involved, that is the husband and wife or domestic partners, but also in case of how the division of assets and debts are going to take place, what is the impact it will be having on the children concerned, etc. So as an edifice to all divorce proceedings, we strongly suggest to our clients that they have an open communication insofar as the initiation of the divorce process is concerned. What this essentially means is it is a tough conversation to break the news of divorce to the other spouse. So many people take the easy way out. They file the petition for divorce, and once the petition is served, the other spouse kind of has a rude shock as to, obviously there are signs that basically would have told the parties that, the marriage isn't going anywhere. But then again, we want to set the right tone at the very beginning so that it's easy for all concerned, which is why we encourage open communication. And especially if children are involved, then we suggest that both parents have a sit down with them and to break the news to them in the best possible manner so that they feel secure, although they may not have the emotional maturity to understand, especially if they are minors. This presentation is not state specific. We've kept it very general so that it deals with only most of the bird's eye view of what the divorce process is. Now, as to the legal requirements, there are these four factors. One is residency, which of course would mean the physical presence along with the intent to particularly and permanently remain in that particular state. Most states have residency requirements that range anywhere between 6 and 12 months. The second would be the waiting period. What this essentially means is the time that lapses between the time of filing the petition for divorce and the finalization of the divorce process. This again is anywhere between 6 and 12 months. The third would be legal grounds. And for those of us from India in this call, we would have heard a lot of grounds by which people back home file for divorce proceedings. Things like adultery, cruelty, impotence, etc. And then there's always divorce by mutual consent. But here in the US, at least on that front, things are a lot more simpler. There are only two grounds. One is irreconcilable differences, and the other being separation. What that essentially means is that the marriage is gone beyond a point of no return, and both parties are acceding to the fact, and that is the reason why they don't believe that there's going to be a retrieval of the marriage. The jurisdictional requirement then again would tie back to the court where the petition is to be filed. And this again would further tie back to the residency requirement that I spoke about a few minutes earlier. So what we've done in this slide and the slide to follow is we've compiled the residency and county requirements for all our offices across the US. Interestingly, California is the only state that has a county requirement of the parties having to reside in that particular county for 90 days. Most of the other states don't have that. And the residency requirements are generally between 6 months and a year, with New York having an exception of 2 years for this particular ground. The two main things here is an uncontested and contested divorce. Apart from the legal requirements that I spoke about earlier, every divorce typically presents four main issues. One is the division of community and or marital property. There is a differentiation between what community and what separate property is. Brinda will be talking about that later. Then there is the division of debt, custody of children, and payment of child or spousal support. So, an uncontested divorce is basically where both the spouses agree that they want to file for divorce, and they come to some kind of an agreement in terms of all these factors concerned. Essentially, in an uncontested divorce, things are a lot more smoother. Sometimes it happens even without the involvement of attorneys concerned. So, they sign a settlement agreement that is then filed with the court, and the divorce is finalized. It's a straightforward process that does not involve a lot of paperwork, as opposed to a contested divorce where things are not that great. Alrighty. So with a contested divorce, like I was mentioning earlier, it's basically where the spouses don't agree on the division of assets, debts, and the other factors. So how this process is initiated is by filing of the divorce petition. The spouse that goes first is the petitioner, and the petition basically it explains what's happened with the marriage, what the date of separation is, what their debts and assets are, and how that particular spouse thinks that they should be divided. Now, the service of process is basically where it's a process by which the petition is delivered to the respondent, who then, that is the other spouse, who then becomes aware that a divorce petition has been filed. Now, once this process has started, the waiting time period that I spoke about previously officially begins for the divorce proceeding. Then, of course, the respondent responds in his response. And in most contested divorces, it becomes a question of, she said, that kind of a thing, where they fight over the assets and how the division should be it child support, be it spousal support. And finally, we then move on to the filings where they disclose the properties and the schedules of assets and debts. And the court then looks into these factors, and there is a judgment. And sometimes, if it's too contested, it even goes to trial. Brinda again will be talking about trial and our 2 cents on that issue. Over to Brinda.
Thanks, Raji. This was informative and insightful. Awesome. So after a divorce is filed and the other party has responded, we come to different aspects of the divorce. So one of them being custody of the minor children. When I initially started practicing family law, Navneet always wanted to patch the parties back together if there were kids involved, because he thought that was in their best interest. But I understand what he was trying to do. He was always trying to look out for the best interests of the kids. So that is exactly what courts look out for. They don't care about you. They don't care about your spouse. They care about the kids, because they are below 18 and there's nobody else to think about them. So they think about their best interest standard and what is in their best interest. And they make decisions accordingly for physical and legal custody. Now, what is physical and legal custody? I get this question asked a lot. And here's how I explain it to all my clients. Physical custody is the amount of time a child spends in each parent's house. All right, that's physical custody. Legal custody is the ability to make decisions for the child, the welfare of the child, like the education decisions, extracurricular decisions, which doctor, which dentist, those kind of decisions. Now, legal custody is always going to be joint unless the other spouse is really awful. They've done domestic violence, or they're a sexual abuser, or they're a drug addict, an alcoholic. And For those reasons, they're unable to make sound decisions for their children. So most courts will always give joint legal custody unless you fall into one of those exceptions that I just explained. And physical custody depends. One parent could be the primary custodian and the other could have visitation rights, or they could have joint 50-50 custody. So that is what custody of children is all about. So child support. Now, what is child support? I know it is every payer's nightmare. Basically, what the judge is going to do is look at the incomes and the amount of time, incomes of both the parents and amount of time the child spends in each household, along with the party's expenses, and come up with a number. They put this number in a software and they come up with a magic number of what this child support number should be. Now, usually the number that they come up with the software from is a guideline amount, but if you're high wage earners, the court can obviously deviate and make an exception from that. So I don't know how many of you remember that popular show, Two and a Half Men, and John Cryer in the show. So there was a very famous case law in 2011 about John Cryer, this actor. And the court in that case ruled that guideline support would be an abuse of discretion, right? Because he was making $327,000 a month. So obviously they were going to deviate from the software calculation because it was in the child's best interest to have a similar lifestyle to the parent. So they deviated from the software number and came up with their own number because he was a high wage earner. So if any of you ever want to look at this case, it's called Marriage of Cryer. So there is a way to waive child support. Yes and no is the answer to that question. Some parents are like, oh, can we waive child support? So the answer to that is no, because it is not your right to waive, it is the child's right. But if both the parents have the child 50% of the time and they are dividing all the expenses equally, there is a way to waive it in your settlement agreement, but make sure that you have very specific language that allows you to waive it. Otherwise, the judge is going to reject your judgment. Now, spousal support, alimony. Now, a lot of people ask, what is alimony? What is spousal support? Well, they're the same terms. They're interchangeable terms. Alimony used to be the old version, and spousal support is the new, modern, refined version. Now, what is that? That basically means that if there is a significant disparity of income between the two spouses, one can ask the other one to pay them spousal support for some time so that they can become self-sufficient and become independent, because divorce is a shock for a lot of people sometimes. Now, California has a different concept of short-term marriage and long-term marriages. I'm sure other states have the same type of concept. So in California, it is up to the judge to give spousal support in a short-term marriage of less than 10 years. And if it's more than 10 years, then there is a rule of thumb that the other spouse will get spousal support for life. Of course, it depends on a lot of factors, income of the parties, their education, their hardships that they suffer, their health, and what their work experience has been. So the court will look at all these numbers and use a calculator, or they will come up with a magic number on their own. All right, so community property. Now, there are only 9 community property states in the US, and California is one of them. So community property basically means whatever you earn during marriage, whether it's income, it's personal property, real property, that is the community's assets that gets divided 50-50 at divorce. So in community property states, that's what a judge would do, draw a line across your assets and debts and divide everything. Now, all states are not community property states, they're equitable distribution states. And they divide assets differently in non-community property states. New York or New Jersey as an equitable distribution state, right?
Yes, New York and New Jersey are both equitable distribution states. It means that each spouse owns the income he or she earns during the marriage or any assets that they have accumulated during the marriage, and also has the right to manage any property that's in his or her name alone. So what happens is when each asset is looked at, so the default rule will go to 50-50, but each asset is analyzed for distribution separately, and there are several factors to be considered when these assets are distributed. One is age and health of each spouse, the length of the marriage, each spouse's income and assets, any health insurance or inheritance rights, whether or not there is a spousal maintenance order from the court, if either spouse has contributions as a stay-at-home parent or a homemaker, or how much each spouse has contributed towards that asset, their earning capacity, tax consequences, and whether either spouse has wasted any material assets, and any other factors that the court might think is relevant based on their individual circumstances. So it's very
So
different.
basically, it's a false jurisdiction, correct?
Correct. Correct.
Okay. Okay, thanks so much for that. It was insightful.
Cool.
So unlike New York and New Jersey, California is a no-fault jurisdiction, including all the community property states. So adultery and all those grounds are not really relevant in California, as and everything gets divided 50-50 unless you've, like I mentioned, those exceptions, done domestic violence or been a sexual abuser, but that doesn't really affect division of assets and debts. That mainly affects spousal support, child custody issues. So that is good to know. Okay, now what is separate property? Because community property states have the concept of community property and separate property. Separate property is basically, and I'm sure it applies in other states as well, anything that you acquire prior to marriage or you acquire during marriage by gift, inheritance, bequest, and you don't commingle those funds and you don't mix them with community funds, and anything that you earn after the date of separation. Now, what is date of separation is a different definition in every state, but in California, it is your objective intention to end the marriage, as long as you clearly communicate to the other that, hey, I don't want to live with you anymore, this marriage is over, and you do not resume marital relations. That is what date of separation really means. So separate property assets are important at divorce because sometimes you've acquired assets before marriage or during marriage by gift, inheritance, or bequest, and you don't want to share it with the other spouse, and you haven't mixed them up with community funds. So you want to make sure that it's not mixed in the community property pool funds. And you want the court to say that, hey, this is your separate asset to the exclusion of the spouse. So it is important to declare everything. A common question that I get asked often, do I have to declare all my assets in the US and any other country, like India, for example? And I always say yes, because at least in community property states, the courts have jurisdiction over any other property acquired during marriage in other jurisdictions, whether it's India or not. And very often I come across these issues, and people are tempted to not disclose, they want to hide their assets. But here's the bad part about that. If your spouse brings it up in court and you were shown as if you were hiding these assets, it is termed as fraud, okay, in layman's language. So, and the punishment for fraud is really bad, because if you can prove fraud, the standard is really high to prove, then your spouse can get 100% of that asset and mandatory attorney's fees for hiding this, and for her to, bring about this whole litigation to show that you are hiding these assets. So I definitely don't recommend that people don't disclose their assets in all countries. I, in fact, always ask them to disclose assets in all countries. So marital settlement agreements, this is when, you've been separated and you've been discussing settlement, and you want to come up with a specific plan of dividing your assets, debts, custody, visitation rights, child support, spousal support, and just move on in life. So an easier way to do this is write a marital settlement agreement and tell the judge how you want to divide your assets and debts. The judges always ask us one question in the court: do you want a third person making a decision about your life, your assets, and how your children should be dealt with? I mean, why don't you guys try to settle this case? So I think that makes perfect sense. The judge listens to so many cases day and night. It is not a personal thing for them. It is not their duty or responsibility to make sure that you are happy with what you get in a settlement and you are happy about what you get at the end of the divorce. It is a very impersonal decision for them. So if you want to make sure that a third person who doesn't have any idea about your dynamics make should not make a decision about your marriage and divorce, then you should try to attempt and settle the case out of court with your spouse, with your spouse's attorney, or get a mediator and help you to divide everything 50-50 in a fair way, or in an equitable way, as other states would like to call it. And typically, if you just come up with an agreement and file it in court, then the judgment should be entered and you can move on in life and be at peace. Remember one thing, if a couple has kids, they're going to be in each other's lives until the kids turn 18. So you don't want to have a sour relationship with your ex-spouse. You always want to have a working and amiable relationship with them. Otherwise, nobody is going to suffer in this process except for you, because you have all those hatred and ill feelings in your heart, right? So it's important that you try to come to a settlement. And if you can't do it on your own, get a mediator, get your attorneys, and ask them to help you out. So the last resort is, if you do not settle, you do not see eye to eye, then obviously you go to trial. Now, what is trial? It is a very time consuming and expensive process. Over the last 9.5 years that I've been practicing family law, only two of my cases have gone to trial. Not because they were big, high value asset and debts case. No, not at all. It was only because the couple would not see eye to eye, would not settle. If one wanted X, the other wanted Y, and they couldn't find a middle ground. So those type of cases go to trial, but I definitely recommend that parties settle their cases. You'd save a lot more money that way, and things would be a lot better that way. So that is kind of what we had today. All right. Thank you so much for joining us. It was nice being here today.